Two former educators are now defendants after being accused of sexual contact with students.
I have teenage kids, and I thought to myself, people are thinking it's a woman. So some people are thinking, well, it's different when a woman does it to a boy. No, it doesn't matter. This is still always wrong.
According to court documents obtained by Law&Crime, 23-year-old Railey Greeson and 24-year-old Brooklyn Shuler have both been indicted by a grand jury for allegedly having inappropriate relations with students.
It's really scary to think that you have employees who are over the age of 18, because they can work at schools, they could be working as a teacher's aide or whatever. That's why we have these laws on the books. You can't do it because you're working there. You can't be, doing the things that these two are charged with, or you'll be charged with a felony. And it's very much right on point, and I'm glad to see it happen.
The pair were both indicted by a Gordon County, Georgia grand jury on June 27th. Greeson was charged with 2 counts of sexual contact by employee or agent in the first degree. Meanwhile, Shuler was charged with 1 count of the same charge.
Well, I'm guessing, and again, I'm only guessing from experience, that these victims are over 16 because the age of consent in Georgia is 16. So if you have sex with somebody and you're 42 and 16, it's not necessarily a cool deal. But when you get to being in a position of authority, or the law used to say a person in custody, the legal term, and this is years ago, was that if you were a psychiatrist, as the statute reads, if you're a psychiatrist with the patient, if you're a nurse with the patient, if you're a police officer with somebody in your custody, or you're in a mental institution and you're a patient, there's a bazillion of them. And if you look at the legislative history in Georgia, it does go down through the years, kind of expanding this. So the way I read it is that these victims were over 16, and what made it a crime is that they were a coach, they were the aide, they were the substitute teacher. It's not real clear what their roles were at the school, and I haven't been able to figure out how old these young ladies are, but I'm assuming early 20s. I don't know.
The charges were brought under a special presentment, which, according to criminal defense attorney Meg Strickler, means a grand jury is meeting outside of their normal schedule to bring about the indictment.
So in Georgia, what it means is that in counties and in judicial districts that are more rural, in Gordon County, interestingly enough, I had I forget, I won't say he was, but he was a person who worked at a school charged with something very similar. So a little bit of an irony. Last time I was in Gordon was on a case like this. But when you go to a more rural, and Gordon County is about an hour and 15 or so from Atlanta, don't hold me, that traffic can make it a lot longer. Once you get out more rural, the grand jury only meets like twice a year, 3 times a year. When you're in Fulton, they meet more often. So the special presentation was, we've got to indict this, so we're going to bring in grand jury solely for this case. And that's what a special presentment means. We went off our normal calendaring times of January to July. I'm making that up. Every county has different rules. But let's pretend that judicial circuit does January and July. They said, well, wait a minute, we want to get this done before the next time we're regularly met to meet. We're going to do a special presentment, and we're going to get to see if there's an indictment going to get brought down by this special group.
And the grand jury indictment revealed more details into what happened. According to court records, Greeson allegedly had sex with 2 different male students between October of 2021 and January of 2022. She's accused of knowingly engaging in sexual intercourse and sexually explicit conduct with both boys while they were enrolled as students. As for Brooklyn Shuler, she allegedly engaged in sexual intercourse and sexually explicit conduct with 1 male student during that same time frame from October of 2021 to January of 2022.
Saying between that period of time, which you can have an indictment do it, say that, which means it happened during that 3-month period, but it's kind of leaving open for a juror to think it was happening the whole time. You see my point? And that's just a thing that gets extrapolated. It's not a legal concept, but it's something that, like, well, wait a minute. It's not saying it happened on December 12th, of 2021. It's saying during a period of time. Makes you think more about, if you're a juror, then do they have proof of it being more than one time? Do they have text messages saying, hey, let me go meet you at the Hampton Inn? I don't know what's here. But the fact that they're co-defendants really makes me wonder, scratch my head. And again, if you get on social media is saying some really bad things about how, and I won't say it here, but they're pontificating some really awful things, and that's probably not true.
Despite the alleged sexual contact happening nearly 3 years ago, Strickler says it's possible there needed to be a lengthy investigation before bringing about the charges.
It's interesting. When I saw those dates, I thought the same thing we all thought. Why? I can tell you in general what could have happened, and then I'm going to tell you what I think did happen here. In general, criminal justice cases can take a year or two to investigate. Okay. So if there's a lot of labor intensive investigations, there are reasons why it takes so long. So in this case, maybe there were some cell phone discussions and they had to wait for the GBI to do their review of the messages, and it took that long. That's the only thing I can think of that's a rational explanation. Short of that, it could be simply they're backlogged because of COVID. And then finally, I think what did happen is that the lawyers, this is what I do in my life, we contact, as soon as these two individuals were interviewed by the detective back in October of 2021, they probably got lawyers right then and there. And then the lawyers have probably been working with the government to find a way to make this be just the dates you said, October 21 to January of 2022. That's a 3-month period. Do you think it's that short? I mean, I don't know. But these are things that we can ultimately knock down. And then there are some laws that make things different too. I couldn't find this data, but how old were these victims? If they were over 16, did they turn 16 during that period of time? So many little wrinkles. That's what's probably been negotiated in the background and why we're only being indicted today. That's what I think happened.
The pair were seemingly 19 years old and 20 years old, respectively, around the time frame the alleged sexual contact occurred. However, the ages of the students were not disclosed in court documents, so it's unclear how old or what grade the students were in when the alleged sexual intercourse began.
Part of this that we've have an indictment handed down, because there is a Romeo and Juliet provision, and I'm using that as a non-legal term, but it is in the statute here. I printed it out that if it's 48 months or less, then it becomes a misdemeanor, and it must not have been, because they're charged, as sure as I can tell, with felonies here. So we don't know yet what's happening and why we got here, because that's a young age, and it's almost, I'm not excusing it, but we all have the excuse of young and dumb. And I'm not trying to say that what's going on here is something that I approve of, or the world approves of. But more importantly, when people are of 18 to 25, there is a young and dumb defense, and they're awful young. They're awful young. But you got to wonder if there's any civil liability for the school district. Why would they employ people so young? You're kind of putting flames to the fire here a little bit.
The indictment also does not detail which school the two women were employed at. However, it's been reported the duo worked within the City of Calhoun School District, but are now no longer employed with the district.
With respect to protecting the schools and the soccer teams, the volleyball teams, and the cheerleading teams, you fill in the blank. They all pass background tests. So we all know that they had no criminal background prior to this. So we know that they're not, they got hired because they were perfectly normal, backgrounds, nothing on it. But you have to realize, and most of the world today makes sure there's protections that these people aren't alone. All right. But what happened here is I have a feeling they were out socially. This didn't happen on school grounds. And so the school couldn't have protected. I'm just guessing, by the way, that it didn't happen on school grounds. Don't know. But most schools these days have a lot of surveillance. There's cameras everywhere. And so I don't know what occurred here. Will they ever be able to be hired again somewhere else? You have a felony conviction. Forget what the felony is. It's going to be difficult to work in many different careers. If you want to get certain licensing, meaning a teacher's license, these people weren't teachers yet, it's going to be very difficult to secure that license because of what the crime was. So I don't think they'll ever teach in any state, much less Georgia, but they can still live their lives, just not in this, the educational world.
I want to thank Morgan & Morgan for sponsoring today's Law and Crime YouTube takeover. If you've seen our videos, you know Morgan & Morgan is a proud sponsor of ours, and our content proves the world is unpredictable and not always safe. When you're hurt, it can be confusing and scary, especially if you don't know where to turn. Well, Morgan & Morgan, America's largest injury law firm, can help. They're the largest injury law firm because they win a lot. And there's a $0 upfront fee. You only have to pay them if you win. So if you've been injured in an accident, you can check out Morgan & Morgan. You can also submit a claim in 8 clicks or less without having to leave your couch. So you can start your claim at www.forthepeople.com/YouTube takeover. And here's what else we've learned about Brooklyn Shuler and Railey Greeson. The duo are best friends. Shuler named Greeson as her best friend and maid of honor in her wedding, according to Zola.com. In a description, it reads, "This girl right here will always be the bride's best friend and forever her sister. She is her ride or die. Life just would not be the same without her. The bride beyond excited for her to stand by her side on her big day."
That's the part that really floors me. I kind of figured they were good friends because that's why they're co-defendants. These things were happening in some sort of, environment where multiple people were together. But when I read that they were each other's maid of honors, and I think I read too that they actually did get married. So the cheating may have occurred, but then they still got married. And oh my, it was a lot. There's a lot here. I mean, I keep using that word salacious. It's salacious because you cheated on them. That's what's alleged. And then they still got married. And then they have the wedding registry and the pictures and all this other stuff. I was snooping too. And I thought, this is bad. Because if you are with a significant other that you wish to marry, what are you doing? What are you doing?
According to the site, Shuler's wedding date is listed as November 12, 2022, a year after she allegedly began sleeping with a student. But it's unclear if the wedding even happened, as it appears the man she was set to marry has wiped all photos of Shuler on his social media page. But it also shows he now has a new wife and they have a child together. But that's not the same for Railey Greeson, whose husband has her plastered all over his social media page. According to her wedding site on theknot.com, she and her husband married in October of last year, nearly 2 years after she allegedly had sex with 2 students. While Greeson was planned to be Shuler's maid of honor in her wedding, Shuler is listed as a bridesmaid for Greeson's wedding. Greeson's husband, whose name we are withholding, even shared this post to his social media page a day after his now wife was indicted for having sex with 2 students. The post reads, quote, "Let he who is without sin among you be the first to throw a stone." While the charges itself could reportedly carry a prison sentence of 1 to 25 years or a $100,000 fine, Strickler explains it's possible the duo might not even get jail time, but could still be put on a sex offender registry.
If this is just stuff happened, and I'm not trying to make it sound less, but the more egregious of the storyline, the more punitive it will be. That's issue 1. Issue 2 is when they were addressed by the detectives back in 2021, did they go get counseling? Did they go get some boundary learning counseling that this is wrong and you need to understand what our values are, et cetera, et cetera? If they did all of that and did mitigating things, then the government probably will offer a sentence that could be friendly. I say could because, again, when you get outside of Metro Atlanta, the jurisdictions are just more conservative and more punitive. Now, I want to say one more thing. Even if they get just probation, if you're convicted of this charge, they're going to be on the sex offender registry, which is like a scarlet letter for the period of time in which you're on it. So, there's a lot of moving parts on this that can really destroy their lives because anybody on the registry these days here in this state is onerous at best, okay? Because you have to make sure you have permission from the sheriff's office that, where my house is approved, and then you're on this magic list that you see at all times and you're like, oof, Brooklyn's a sex offender. It's going to follow her. So the lawyers have a lot of work to do on the mitigating. I'm speaking like a defense lawyer here. But I don't know enough about the case on the egregiousness of it to say if prison time would be part of the equation. When I looked at this case, and I've had a few of them actually, I've had a couple female clients charged with these things. And what you see in the comments from everybody, be it, interacting personally or on social media or in the courts, is now the prosecutor never thinks this, but in general, you'll hear comments from men being like, well, I wish my teacher looked like that, and those kinds of things. And it kind of just normalizes it. And when you're a mother of the 15-year-old, the 16-year-old, the 17-year-old, you would really have a different point of view. There's a reason why it's not okay. And I think the key point here, we need to get rid of the gender concept and simply think about the position of trust that a teacher, substitute teacher, an aide, somebody's working at your school. Remember, these are 16, 17, 18. They're still children. They think that that person is somebody they look up to. It's not somebody to have sexual relations with.
According to reports, both Railey Greeson and Brooklyn Shuler turned themselves in after the indictment into the Gordon County Jail on a $10,000 bond. Since then, they have both been released from jail. Reporting for Law and Crime, I'm Elizabeth Millner.